Number 1 on the list is Mark Ciavarella. Imagine being 15 years old. You built a fake MySpace page mocking your assistant principal. Your parents are called in. You appear in court without a lawyer. The judge looks at you for a matter of seconds, bangs his gavel, and sends you to a juvenile detention facility. You are handcuffed. You are taken away. Your parents are left standing in a courtroom in Luzerne County, Pennsylvania, trying to understand what just happened. What they did not know, what nobody outside a small circle of conspirators knew, was that the judge who just sentenced their child had been paid to do it. Stop right here and tell me in the comments, when someone in uniform does this, do they deserve harsher punishment than a regular criminal? Comment your answer below. That child was Hilary Transu, one of more than 2,500 children whose lives were altered by what federal prosecutors would eventually describe as the largest judicial corruption scandal in American history. The judge was Mark Ciavarella. In the scheme he ran with a fellow judge, Michael Conahan, for years inside the Luzerne County Court of Common Pleas in Wilkes-Barre, Pennsylvania, became known across the country by 3 words that still carry a particular kind of revulsion when spoken together: kids for cash. Mark Ciavarella was born and raised in Wilkes-Barre, Pennsylvania, the son of a working-class northeastern Pennsylvania family in a region shaped by coal mining, labor history, and tight community ties. He attended King's College in Wilkes-Barre and eventually earned his law degree, establishing himself as an attorney in the region before seeking elected office. In Pennsylvania, judges of the Court of Common Pleas are elected by popular vote, and Ciavarella built the reputation of a tough, no-nonsense arbiter who took juvenile crime seriously. He was elected to the Luzerne County Court and eventually became the juvenile court judge, the person responsible for deciding the fates of children who came before the system. He presented himself publicly as a zero-tolerance advocate, a judge who believed that early, firm intervention was the way to steer troubled youth away from worse outcomes. The community largely accepted this framing. Behind that presentation, according to federal prosecutors and the evidence presented at trial, was something else entirely. The scheme began around 2002 and continued until 2008. According to court records from the federal prosecution, Ciavarella and Michael Conahan, who served as Luzerne County's president judge, entered into a corrupt arrangement with 2 men, Robert Miracle, a real estate developer who built 2 private juvenile detention facilities, PA Child Care and Western PA Child Care, and Robert Powell, a co-owner of those facilities. The arrangement, as prosecutors documented it, was straightforward in its mechanics and staggering in its scale. Conahan used his budgetary authority as president judge to defund and shut down the county's publicly operated juvenile detention facility, eliminating the alternative. Ciavarella then began filling the private facilities with a steady, profitable stream of juveniles, many of whom had no business being detained at all. In exchange, Miracle and Powell funneled more than $2.5 million in illegal payments to the 2 judges, concealed through a variety of financial arrangements including payments routed through a company Conahan controlled in Florida. What this looked like in practice was documented in case after case reviewed by investigators and later by the Pennsylvania Supreme Court. Children as young as 8 appeared before Ciavarella. Children accused of jaywalking, of trespassing in a vacant building, of getting into a slap fight in gym class, of truancy. More than 50% of the children who appeared before Ciavarella lacked legal representation. Court records show that many hearings lasted less than 2 minutes. Ciavarella's courtroom ran at a pace that defense attorneys described as incompatible with any genuine assessment of the cases before him. One attorney stated that even if Lee Bailey could not have helped the children who came before Ciavarella, they were going away regardless of what anyone said. 60% of the children Ciavarella removed from their homes were sent to the private facilities whose owners were paying him. The Pennsylvania Juvenile Law Center, based in Philadelphia, began receiving requests for help from affected youth as early as 2007, and their attorneys determined that hundreds of cases had been tried without adequate legal counsel. The investigation that brought everything down was launched by the FBI and the IRS working in parallel. Federal prosecutors in the Middle District of Pennsylvania built the case methodically, following financial records, interviewing witnesses, and documenting the flow of money from the facility operators to the judges. On January 26, 2009, federal prosecutors held a press conference and publicly announced the charges, detailing the kickback scheme that had allowed the 2 judges to wrongfully imprison thousands of children for their own financial benefit. Both judges were charged. Conahan entered a guilty plea to racketeering conspiracy. Ciavarella rejected a plea deal that federal Judge Edwin Murnane refused to accept anyway, finding that the defendants had not accepted genuine responsibility for their wrongdoing. Ciavarella went to trial in 2011, denied that the payments constituted bribes, and characterized them as legitimate finder fees for referring business to the facility developer. The jury did not accept this. He was convicted on 12 of 39 counts including racketeering, mail fraud, money laundering conspiracy, and filing false tax returns. On August 11, 2011, he was sentenced to 28 years in federal prison. He was also ordered to pay more than $1 million in restitution. The Pennsylvania Supreme Court subsequently overturned approximately 4,000 juvenile convictions connected to his courtroom, one of the largest mass exonerations in state history. Ciavarella appealed his conviction and sentence extensively. Every appeal was denied. As of the most recent verified records, he is serving his 28-year sentence at a federal penitentiary more than 1,000 miles from Wilkes-Barre, designated inmate number 15008-067. He will be in his 80s before he is eligible for release, and most legal analysts consider it unlikely he will outlive his sentence. He has given interviews from prison expressing that he does not believe the evidence supported his conviction. The children whose cases were overturned have described in documented accounts the psychological damage, the derailed educations, the broken family relationships, and the lasting trauma that followed them out of the facilities he sent them to and into their adult lives. And while what Ciavarella did is already among the most disturbing abuses of judicial power on this list, the final case you will hear today involves a judge who received the single harshest prison sentence of any judge convicted in the entire Operation Greylord investigation, an 18-year term for extorting more than $200,000 from lawyers who appeared before him, a man who died in relative obscurity but whose conduct inside a Chicago courtroom shaped constitutional law across the country. That story is coming.
If you enjoy real prison documentaries like this, make sure you like, comment, share, and subscribe to the channel. And hey, don't forget to hit that subscribe button so you don't miss the next documentaries every week.
Number 2 on the list is Michael Conahan. He stood in a federal courtroom in Scranton, Pennsylvania, on September 23, 2011, and said 6 words that have been quoted in every account of the case ever since. Looking at the judge who was about to sentence him to 17.5 years in federal prison, he said, "The system is not corrupt. I was corrupt." It was an admission that arrived late, that came only after a guilty plea to racketeering conspiracy, and that landed in a community still processing the scale of what the man before them had done. Michael Conahan had been one of the most powerful judicial figures in Luzerne County, Pennsylvania. He had used that power, alongside a fellow judge, to run a scheme that made children into a commodity and turned their suffering into a revenue stream. Michael T. Conahan was born in 1951 and grew up in northeastern Pennsylvania, a region whose identity has long been shaped by labor, Catholic community life, and a deeply embedded sense of local institutions. He attended college and law school, entered the legal profession, and built a career that brought him to the Luzerne County Court of Common Pleas, where he eventually rose to the position of president judge, the administrative head of the county court system, responsible not only for adjudicating cases but for managing budgets, personnel, and the institutional operation of the entire court. It was a position of extraordinary power in a mid-sized Pennsylvania county, and Conahan held it from 2002 to 2006. According to federal court records, the corruption that would eventually destroy him began even before he assumed the presidency of the court. The scheme Conahan operated alongside juvenile court judge Mark Ciavarella was built on a simple financial logic that was hidden inside legitimate-sounding institutional decisions. Robert Miracle, a real estate developer with deep ties to Luzerne County politics and commerce, had built 2 private juvenile detention facilities in the region, PA Child Care and Western PA Child Care. Robert Powell was a co-owner of those facilities. Both men needed a steady flow of juvenile offenders to make their investment profitable. Conahan, as president judge, had the authority to direct the court's budget and institutional relationships. According to prosecutors, he used that authority to shut down the county's publicly operated juvenile detention facility, the Luzerne County Juvenile Detention Facility, by simply stopping its funding. With the public alternative gone, the private facilities became the only option for juvenile detention in the county. Ciavarella then supplied the bodies. And in return, according to the financial records assembled by federal investigators from the FBI and IRS, Conahan and Ciavarella received more than $2.5 million in payments from Merkel and Powell, routed through various concealed channels including a company Conahan controlled in Florida. The Pennsylvania Judicial Conduct Board received 4 separate complaints about Conahan between 2004 and 2008. According to documented records of its own failure, the board investigated none of them. In 2006, the FBI received a tip about nepotism in the Luzerne County courts and began a parallel investigation. Separately, the Juvenile Law Center in Philadelphia began receiving distress calls from affected youth and their families and began reviewing hundreds of cases for legal deficiencies. In April 2008, the center petitioned the Pennsylvania Supreme Court on behalf of children whose civil rights had been violated. The state Supreme Court initially denied relief, then reconsidered in January 2009 when federal corruption charges against both Conahan and Ciavarella surfaced publicly. Federal prosecutors announced the charges on January 26, 2009. The announcement detailed the full mechanics of the kickback scheme and named both judges. Both Conahan and Ciavarella initially agreed to plea deals that would have resulted in sentences of 87 months, approximately 7 years, in prison. Federal Judge Edwin Murnane rejected the plea agreement in July 2009, finding that the defendants had not accepted genuine responsibility for the harm they had caused to thousands of children and their families. Conahan subsequently entered a new guilty plea to racketeering conspiracy in 2010. On September 23, 2011, he was sentenced to 17.5 years in federal prison and ordered to pay $874,000 in restitution. He acknowledged at sentencing that he alone bore responsibility for his actions. Now that you know what happened, here's the question that divides people every time this case comes up. Was justice truly served here, or did the system get it wrong? Comment below. I read every single one. In 2020, with 6 years remaining on his sentence, Conahan was released to home confinement under provisions related to COVID-19 and his documented health conditions. The decision drew criticism from victims and their families, who argued that the early release extended an already diminished sense of accountability for a man whose conduct had produced mass psychological harm to thousands of minors. On December 12, 2024, President Joe Biden commuted Conahan's sentence as part of the largest single-day grant of clemency in modern presidential history. The commutation eliminated the remaining time on his sentence. Pennsylvania Governor Josh Shapiro stated publicly that he strongly disagreed with the decision and that it created pain in communities across northeastern Pennsylvania. Victims and their families expressed anger and distress. Marcia Levick of the Juvenile Law Center acknowledged the commutation while expressing hope that Conahan had reflected on the harm he caused. The Pennsylvania Supreme Court had previously overturned approximately 4,000 juvenile convictions tied to the scheme. Mark Ciavarella, who went to trial and was convicted, continues to serve his 28-year sentence. Michael Conahan, as of the most recent verified records, is free. Number 3 on the list is Thomas J. Maloney. The agents working Operation Greylord knew from the beginning that what they were dealing with in the Cook County courthouse system was not isolated corruption but a culture. The FBI investigation, launched in the late 1970s, eventually resulted in the indictment of 93 people across Chicago's court system, 17 judges, 48 lawyers, 10 deputy sheriffs, 8 police officers, and various court officials. Most of them were convicted. But when federal prosecutors and the investigative team looked across the full scope of what they had uncovered, one name stood apart from all the others. The Seventh Circuit Court of Appeals, in its written opinion on his case, opened with a line that captured what Thomas Maloney represented. This is yet another in an unfortunately long line of public corruption cases which have left a blot on the escutcheon of Chicago justice. Even by the standards of a scandal that had already shaken a city, Maloney was, as the web magazine Judiciary report would later put it, the worst of the worst. Thomas Joseph Maloney was born in 1925 in Chicago, Illinois. He had been a boxer in his youth, a physical background that fit the aggressive, domineering courtroom persona he would later cultivate as a judge. He studied law and was admitted to the bar in 1952, building a career as a criminal defense attorney in Cook County with documented connections to Chicago's underworld. According to federal court records and investigative accounts of the case, before Maloney ever put on a judicial robe, he was already embedded in the culture of corrupt transactions that defined the margins of Chicago's legal system. One documented example of his prejudicial conduct involved facilitating a payment to a judge who subsequently acquitted Harry Aleman, a mob hitman, of murder in a case that became one of the most notorious examples of a fixed murder trial in Chicago history. Maloney shared an office for some time with Edward Verdaliak, a powerful political operative whose name was repeatedly associated with the machinery of Chicago influence and corruption. Maloney was elected to the Cook County Circuit Court in 1977. He served as what Chicago insiders called a heater judge, someone assigned to high-profile, high-intensity cases that generated significant attention and, in a corrupt system, significant opportunity. He developed a public reputation as a severe, no-nonsense arbiter who sent people to death row at a rate that exceeded nearly any other criminal court judge in the county during his era. According to documented records, he imposed death sentences more frequently than almost any of his peers. That public image of uncompromising severity was precisely the cover under which his corruption operated. While defendants who could not or did not pay faced the full weight of his documented harshness, those whose attorneys could arrange payments through intermediaries received something else: an acquittal, a reduced charge, a favorable outcome that had been purchased before the verdict was ever announced. The mechanics of the scheme, as established by federal evidence and the jury's findings, involved the use of intermediaries known as bagmen. Maloney's primary bagman for a period was a court bailiff named Lucius Robinson, who served as the conduit between defense attorneys seeking to fix cases and the judge who could deliver outcomes. When Robinson's reputation became a liability as Operation Greylord's investigation expanded, Maloney adapted by using other channels. According to court records, Maloney fixed at least 4 cases during his time on the bench, including 3 murder cases. In one documented case, he acquitted members of a Chicago gang in a murder prosecution for a payment delivered through the bagman system. In another, he received money intended to guarantee a particular outcome in a death penalty case. The amounts paid, according to federal evidence, exceeded $100,000 across the fixed cases. What makes the Maloney case uniquely disturbing is a documented behavior that federal prosecutors and legal analysts described as particularly cynical. On at least one occasion, Maloney accepted a bribe from a defendant's attorney and then, suspecting that federal investigators were watching, convicted the defendant anyway to deflect suspicion from himself. The defendant's conviction was later vacated precisely because a judge who had accepted money to fix the case could not be considered impartial regardless of the ultimate outcome. According to court records from subsequent proceedings involving cases Maloney had presided over, his willingness to take bribes for acquittals had what prosecutors described as a sinister flip side. Defendants who had not paid, or who appeared in the same case alongside defendants who had, could face harsher treatment specifically because it made the bribed outcomes less visible. Maloney was indicted on June 26, 1991, by a federal grand jury. His trial began in March 1993. He was convicted on 4 counts related to accepting bribes, including fixing 3 murder cases, and was also convicted of racketeering conspiracy, extortion under color of official right, and obstruction of justice. He was the first, and according to multiple legal authorities remains the only, Cook County judge ever convicted of rigging murder cases for cash. He was sentenced to 15 years and 9 months in federal prison. He served approximately 12 years and 3 months before his release. After his release he was placed on home confinement. He maintained to his death that he had been wrongly convicted, blaming the prosecution, the witnesses against him, and what he characterized as overreaching by federal investigators. Thomas Maloney died in 2008, the same year he was released from the final stages of his sentence. He was 82 years old. He never admitted guilt. Number 4 on the list is Reginald Holzer. August 5, 1983. A corrupt court clerk and a corrupt Chicago police officer, both of whom had been approached by the FBI to cooperate in a sprawling undercover investigation of Cook County's judiciary, leaked word of the operation to the media. The investigation, called Operation Greylord, named, with deliberate irony, after the powdered wigs worn by British judges, became public knowledge in Chicago. What followed over the next decade was the systematic dismantling of a culture of judicial corruption that had been operating in plain sight inside the nation's busiest criminal court system. 93 people were eventually indicted. 15 of 17 implicated judges were convicted. And of all the sentences handed down across the entire multi-year federal prosecution, the single longest prison term, 18 years, went to a Cook County Circuit judge named Reginald J. Holzer. His was not a case of fixing murder trials or taking gangland payments. It was something methodical, sustained, and in its own way more brazen. He simply used his judicial position as a personal ATM, extracting money from lawyers who appeared before him in exchange for the implied promise of favorable treatment, and he did it for years. Reginald Joseph Holzer was born in 1928 in Chicago, Illinois. He built a career as a lawyer and eventually won election to the Cook County Circuit Court, where he served as a trial judge handling civil and criminal matters. According to federal court records from his prosecution, Holzer developed a practice of soliciting what he described as loans from attorneys who had cases pending before him. The arrangement operated through a straightforward dynamic that the Seventh Circuit Court of Appeals, in its written opinion affirming his conviction, described with notable precision. He received money from persons appearing before him in his official capacity, and he concealed this systematically, including by failing to list the payments on his required Rule 68 financial disclosure statement and through clandestine meetings with attorneys even after the FBI investigation had become known to him. The amounts were significant. Federal prosecutors documented that Holzer had solicited and received more than $200,000 in payments across multiple attorneys and cases over an extended period. The attorneys who paid, according to the evidence assembled at trial, did so because the implicit message of Holzer's requests was understood. A judge asking a lawyer for a loan is not making a neutral request. The power differential between a sitting judge and an attorney with pending litigation before that judge made every such solicitation something closer to extortion than borrowing, and the Seventh Circuit agreed with this characterization when it affirmed his conviction under the Hobbs Act, which governs extortion under color of official right. Investigators working Operation Greylord built the case against Holzer through financial records, witness testimony from attorneys who had been solicited, and surveillance operations that documented his continued conduct even after the investigation had been publicly announced. One particularly damaging piece of evidence, according to court records, was the documentation of a clandestine meeting Holzer arranged with one of the attorneys after the Greylord investigation was already underway, a meeting that demonstrated consciousness of guilt in an attempt to manage the evidence trail even as federal investigators were watching. He never publicly acknowledged the corrupt nature of what he was doing. He characterized the payments as legitimate personal loans between colleagues and maintained that his judicial rulings were never improperly influenced. The jury did not find this convincing. In 1986, Reginald Holzer was convicted by a federal jury of mail fraud, extortion under the Hobbs Act, and violation of the Racketeer Influenced and Corrupt Organizations Act on 27 total counts. He was sentenced to 18 years in federal prison, the stiffest sentence imposed on any judge convicted in the entire Operation Greylord prosecution. Holzer appealed his conviction to the Seventh Circuit, which affirmed it in a detailed 1987 opinion that established important legal principles around what constitutes fraud and extortion when committed by a public official through the abuse of fiduciary relationships. His petition for certiorari to the United States Supreme Court was denied. His 18-year sentence was later reduced to 13 years, and he was released from federal prison camp in 1990 after serving approximately 4 years. He died in 1992. In a letter written from the federal prison camp in Oxford, Wisconsin in December 1987, Holzer wrote to a Chicago publisher that he stood before the court a convicted felon, exhausted, disrobed, and defeated, and acknowledged that his crimes had destroyed him and wounded his family beyond measure. By the time of a later letter from the same facility, he was already characterizing Operation Greylord differently, as an investigation he had merely been swept up in, rather than one whose central finding, that he had systematically extorted money from the lawyers who appeared before him, he fully accepted. Number 5 on the list is Patrick Hale Dejean. To the people who elected him, Patrick Dejean was exactly what a justice of the peace was supposed to be, a local official, embedded in his community on the west bank of Jefferson Parish in Louisiana, accessible to ordinary people, handling the small claims disputes and debt collection matters that larger courts had no time for. He had won his seat on the Second Justice Court in Jefferson Parish in 2008, and he served as the elected judge for an area of Marrero that depended on his court to resolve the kinds of financial disputes that working people brought to it: creditors chasing unpaid debts, employers receiving instructions on wage garnishments, banks processing small loans. He was 40 years old when federal investigators caught up with him. He had been stealing from every one of those people, the creditors, the debtors, the banks, for 7 years. And he had been spending the money almost entirely at local casinos. Patrick Hale Dejean was born in Louisiana and built his life on the west bank of Jefferson Parish, a community on the south side of the Mississippi River across from New Orleans proper. He studied law, entered the justice system through the electoral process in 2008, and was entrusted with one of the smallest but most immediate judicial roles in Louisiana's court structure. Justices of the peace in Louisiana handle low-level civil disputes. They do not conduct jury trials but serve as the first point of institutional contact for creditors seeking payment from debtors who have fallen behind. In the Second Justice Court of Jefferson Parish, this meant Dejean regularly issued garnishment judgments, formal legal orders instructing the employers of debtors to withhold a portion of their wages and send those funds directly to the court, which would then forward them to the creditors who had obtained judgments. According to evidence presented at his federal trial, what Dejean actually did with those wage garnishment funds was something very different from forwarding them to creditors. Federal prosecutors documented that from May 2009 through August 2016, a period of 7 continuous years, Dejean systematically diverted money from the Second Justice Court's bank account for his own personal use. He did not forward the proper amounts to creditors after collecting garnishments from debtors' employers. He continued to garnish wages from unsuspecting workers even after the underlying debts had already been fully paid, extracting additional money from people who owed nothing more and were entitled to have the garnishment stopped. He also applied for bank loans on behalf of the court, something that Louisiana law explicitly prohibited, lying to the bank on the applications and falsely representing the purpose of the loans. According to prosecutors, he borrowed more than $50,000 from First Bank and Trust through these fraudulent applications in 2012 and 2013, then used those funds, like the diverted garnishment money, primarily to gamble at local casinos. The people Dejean stole from were not wealthy. They were working people in Jefferson Parish, employees whose wages were being garnished, creditors who were owed money they never received, banks whose loan officers were deceived by false documents. U.S. Attorney David Joseph, who prosecuted the case, described it precisely when he said that Dejean had targeted some of the most vulnerable members of society, stealing their hard-earned wages, defrauding banks, and abusing the trust placed in him by the public. The investigation was conducted by the U.S. Attorney's Office for the Western District of Louisiana because the Eastern District Office in New Orleans had to recuse itself. Dejean's wife worked in the administrative section of that office, creating a conflict that required the case to be prosecuted out of Lafayette instead. The federal jury deliberated for approximately 3 hours following a 9-day trial that concluded on February 27, 2019. The verdict was guilty on all 16 counts, 13 counts of mail fraud and 3 counts of making false statements to a bank. Dejean was 40 years old. Sentencing took place before U.S. District Judge Mary and Vile Lemon on October 10, 2019. In a notable moment during the proceedings, Dejean's aunt attempted to address the court directly, was denied, and was ultimately removed from the courtroom after approaching the bench uninvited with printed materials about gambling addiction, shouting as she was escorted out that gambling was a disease that affected the brain. The judge sentenced Dejean to 3 years in federal prison, 3 years of probation, and ordered him to pay $73,046 in restitution to his victims. Lemon indicated she would recommend a minimum security federal prison camp near Pensacola, Florida, which Dejean's attorneys had requested. Every case in this video came from real court records, real investigators, and real people who trusted the legal system and were betrayed by the very individuals sworn to uphold it. From children sentenced to detention for profit, to lawyers extorted by the men who were supposed to rule impartially on their cases, to working people whose wages were stolen by the judge who was supposed to protect their rights, every one of these stories happened. If any of them stayed with you, drop a comment. Tell us which case affected you most and why. And if you want more documentaries like this one, subscribe to Real Prison Files. We will keep bringing you the truth.